the appeal element of the king on the application of the roads and working.
My lady, appearances. I appear for the appellant with Mr. Royston, who appeared below. The Secretary of State for Work and Pensions is represented by Ms. Clement, and Ms. Eddy, instructed by the GIT. We should have 3 bundles, virtual or electronic. Mercifully, there are no hand-ups.
Excellent.
It's always great when you can say that. And as to timetable,
yes,
I've liaised with my learned friend. She fairly says that she accepts the burden of opening the case and the materials is on me and I need a bit more time. She thinks 2.5 hours or thereabouts should suffice for her purposes. I'm aware we're starting late tomorrow afternoon. I'm going to do my damnedest to be finished by 12 o'clock tomorrow or earlier. That would give my learned friend the time she requires and half an hour or so.
So you think you need 4 hours, is that right?
In total, yes.
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 All right.
I want to take you through the materials quite carefully. That's where I think the value.
Yes. All right. Well, so but you think that you'll be finished by 12, and that will enable us, even if we have to sit a little late tomorrow to finish within the time.
Yes, my lady.
We can go till 4:30 today.
What day is it? Sorry.
Wednesday.
Wednesday, no, yes, I think that's fine then, yes.
Wednesday the 25th.
Yes,
Yes.
that's fine. Right.
Good. Yes.
So, the way I'm proposing to approach this is as follows. Firstly, I'm going to give you a relatively lengthy introduction. I'm conscious, obviously, you've read and thought about the skeleton argument. I do want to frame some of the issues around what I'm going to call the no new claims policy.
Yeah.
Secondly, I'm going to take you through the general statutory framework and the associated case law, by which I mean the provisions relating to the SSAC and the public sector equality duty, because they're background considerations you need to have in mind when then going through the detail of the actual regulations and the materials surrounding them in play. And I'm going to do that as my third section. I'm going to go through the development of the law and what is said about the law and the policies in a chronological fashion, starting in 2012 and finishing in 2020. Then I'm going to be no more than a couple of minutes on the facts of my client's case, and then I'm going to take my grounds. And I'm not going to take them in the order of the skeleton argument. I'm going to take ground 1 first, ground 2. The second ground I'm going to take is ground 4, the public sector equality duty argument, because that sits very naturally with the consultation arguments. Then I'm going to take ground 3 and then ground 2. Sorry, ground 2 and then ground 3.
Ground 2, then 3.
Then 3. So it's 4 that's being promoted.
Yes. Okay.
So the background to this case is as follows. It's long been benefits law and policy that those in full-time education can't access a raft of benefits. And the policy behind that rule is clear. Those in tertiary education are expected to work, or in certain circumstances, and this is tailored through the amount of maintenance in the grant, they're expected to receive a measure of support from their families. And it's that support that is meant to provide for all their cost of living. That rule of thumb has always been subject to certain exceptions, broadly targeted at those who can't reasonably be expected, for whatever reason, to work. And amongst those are those with disability, and that's achieved in the scheme of the 2012 Act by exceptions made under regulations under Section 4. And indeed, it's an exception from one of the basic conditions, as it's called in the jargon, which is the basic condition that you're not in full-time education. Now, for universal credit, that exceptional rule was and always has been contained in Regulation 14, as varied from time to time. The rule, at its most general form, provided, timing issues aside, that's issues about the determination, the date of determination aside, it provided that a disabled person fell within the exception if 2 conditions were met. The first is that they were entitled to receive one of the 3 relevant benefits for the disabled. That's attendance allowance, DLA, or a PIP. First condition. Second condition, that they had been assessed to have the status of limited capacity for work. And as you'll have seen from the papers, LCW is not a benefit, it is a status used across a raft of benefits. And those two substantive conditions have been a constant in the three forms of Regulation 14 that you're going to have to look at. And the second of those substantive conditions, the need to have LCW, is a change from the system that previously prevailed. Because under the
A change in 2012.
in 2012. It's a change because under the previous system there was a presumption that parties with such benefits could not work, and it was only if the Secretary of State chose to effectively initiate an assessment which revealed a capacity to work that the presumption was displaced.
I don't to take you out of your stride, but you say work or support from families. There is a third part of the universe. There's been formerly tuition grants, but not now. But there are grants and there are loans.
Indeed, and they're taken into account in the calculus of universal credit, and I'm going to show you some calculations.
We've seen that, but in terms of setting it up, it wasn't they either work or their families helped
Yes.
them. They could qualify for loans or in the old days maintenance grants, and or their families could help them.
Absolutely.
Or they could work. So it's not just work or support from families.
Absolutely right, Michael, and I don't intend to be pernickety by saying actually that the maintenance element is treated effectively as income, and it's income you're expected to obtain, so if you don't take out a loan, it's nevertheless counted against the amount of universal credit you can receive. So it's a species of income that doesn't come from work, but it's treated as income. So very fairly and fully, the Secretary of State for Work and Pensions has set out the scheme that preceded the changes in 2012, and you get an explanation of that in section 17 of Miss Garrett's first witness statement, and that explains the main change is in relation to the broad presumption being replaced with a far narrower set of presumptions that are contained in Schedule 8 of the regulations. In Schedule 8, the version in the authorities bundle is a bit garbled, but it provides for a certain very narrow set of circumstances in which inability to work is presumed. You're in hospital, you have a condition like dialysis requiring constant attention at hospital, you're terminally ill, it's matters like that. So that's a substantive change, and that substantive change was patent on the face of the regulations, because all you had to do was read the old 14B, and you would see that there was this additional requirement that you had been determined to have LCW, and it was consulted upon. But there is a second change that has occurred since the old system. It occurred at some time between 2012 and 2017, and ultimately it probably matters not when it occurred. The change is this, that the Secretary of State adopted a further policy that was further intended to restrict the scope of the application in favour of disabled people. The policy is that described in section 28 of Miss Garrett's first witness statement, supplementary bundle, tab 6, page 120, sets out the policy verbatim. You need to read that evidence with her second statement and Miss Cadd's statement. And if you put them all together, what you get to is a position as follows. This is a later, in fact, post-litigation version of a policy first adopted in an identical or similar form, version 8, first adopted in, I think, November 2018. It's version 14 that is the first to refer to what is in effect what I call the new claims policy. You see that at supplementary bundle, tab 5, page 103. And it's this policy that then operated to set right those benefits offices that were in the course of 2017-2018 were operating to effectively allow an assessment even after the claim had been made. Now, this policy operates to this clear effect. It says that unless you have had a determination before you make entry into education, not before you make a claim, you will not be considered for universal credit. And as such, through the universal credit regulations as applied pursuant to this policy, it was impossible under those regulations to obtain LCW status. Now that policy is not only in no way patent on the face of the regulation, it has been held by the first tier tribunal and accepted before the administrative court to be impossible to reconcile with the obligations under those regulations. In other words, the policy was inconsistent with the law as publicly expressed, unlawful.
Well, that was the reason for the settlement in the Cowser litigation.
Indeed.
And there had previously been a finding made in the tribunals to similar effect.
Indeed.
Yes, but the Secretary didn't set out, she didn't get up and say, oh, I know what I'm going to do, I'm going to act unlawfully, let's get away with it. What she thought she was doing was acting lawfully. And because of complicated regulations, and she's only human, she made a mistake. But I mean, you're building quite a big pillar at the moment that this was a new policy, the rules were clear, and she decided to operate an inconsistent policy. It may just have been a bit murkier.
Well,
but does it matter?
Well, it does matter,
right?
Because it feeds into, at least, most obviously, the first two questions, which is the rationality of the decision not to consult and the discharge of the public sector equality duty. Those two issues are linked. The simple forensic point I'm making presently is that until the policy was effectively announced to Disability UK in March 2017, there was absolutely no material to even suggest the existence of the policy. You couldn't pick up the regulations and say there is or might be such a policy, because if you did, you'd do exactly what Judge Pointer did in the Badu litigation and say, well, you need an assessment. How do you get an assessment? Under the provisions of the regulations that provide for an assessment, you obviously have to have an assessment because it's a condition of the benefit. Ergo, have your assessment. That's how anyone would.
So the position is the regulations did not provide for it. From at least March 2017, people knew that the Secretary of State thought they didn't allow provision for it, or, on your case, she deliberately decided to carry on with the policy, even though it wasn't provided for. So that's the position. The rules said one thing, and that was the law. And then from at least March 2017, she was telling people that she was going to do something different. And two people spotted it, Mr. Cowser and the FTT tribunal judge. And that's where we are.
The relevance of the position for the purposes of consultation lies in the fact that the express reason that the Secretary of State has committed to repeatedly and in all the relevant documents as to why there was no consultation was that the regulation in 2020 restored the original intention behind the 2012 regulations, 2013 regulations. That was the reason given, and that's why the content of the original regulations, its objective meaning and content is relevant to the consultation question. The reason why the time period for when the policy is adopted may be relevant is because the public sector equality duty, as summarised in the Bracking case, requires you to consider the implications of the policy before and at the point in time of the adoption of the relevant decision, and as a continuing duty thereafter. And with respect, the longer it's been the Secretary of State's policy, lawful or not for this purposes, it matters not, the longer the Secretary of State has been fixed with duties under the public sector equality duty in relation to that policy. And you will see that it is an important part of the attack on the 2020 EIA that it was preceded by somewhere between 4 years and 8 years of actual implementation of this policy.
But so what? She wasn't doing an EIA on the policy. She's doing an EIA on the fact she was changing the law so that the law did do what she wanted it to do, whether she wanted to do it and believed it was doing it earlier. What they were consulting on 2020 EIAs was not the previous policy, but the change in the legal instrument, which means that as a matter of law, that is what the position would be.
Well, with respect, my lord, that can't be right, because
Why not?
there hasn't been an EIA
No.
or any discharge of the PSED at all in relation to the old policy.
Absolutely. And isn't it a relief that you're not challenging the old policy? Because we'd have to spend a lot of time wondering whether the old policy was unlawful. But the EIA is an EIA. What you are challenging, well, what you're actually challenging is the decision not to accept his universal credit, which is based on the 2020 regulations. And the EIA was an EIA of the 2020 regulations and what those regulations lawfully did, which was to say you can't get UC unless you got the determination before.
The 2020 regulations address for the first time the legality from the perspective of the PSED of the policy that you should not be entitled to claim unless you have established LCW before your entry into education. That is the substantive issue that is being considered by the policy. That is the substantive policy the EIA addresses.
Yeah.
And in addressing that substantive policy, the fact that the policy has already been in operation for between 4 and 8 years is relevant. Why? Because it affects your ability to approach the issues with an open mind. It affects whether or not you were able, in the intervening period, to gather and did gather data about the operation of the policy. It affects whether or not this is
the fact the policy in operation, to go through more slowly, I don't know yet whether you agree that it is an EIA of the 2020 regulations or not. But in any event, you say that the fact that there was a policy in operation for a number of years, albeit unlawfully, is relevant. Just give me that list again more slowly.
It's relevant because the obligation is to consider the discharge of the PSED before, during and after the point in time of the decision.
And you say that 8-year period enabled the Secretary of State to gain evidence and data that would support the discharge
Absolutely.
of the... Right.
How many claimants are being refused?
Yeah.
What
Okay.
is the financial consequences for them? What grants are being provided by the local authorities?
Hold on.
And is this an argument that was run before the judge? Because I don't...
I'll take you through how it was run.
Okay.
I'll
I think it
Can
was
you go a
run
bit-
in a slightly different way.
Can you go
Anyway.
a bit, so obtain data, and then there's a stream of things, and I've got nothing after obtain data.
Well,
so the data that you say that
Data
is
and
missing-
evidence about...
Yeah.
with respect, rather pulling me into the substantive grounds, which I was going to open when we got to that point, I think the only point I wish to establish in opening is that the past history of the practical, whether it's lawful or not, operation of and implementation of the policy is relevant to the consideration of the PSED at the first point in time.
Okay, and I'll have to wait, and you'll tell me sometime before 12 o'clock tomorrow why it's relevant then. So we'll have it then, yeah.
I will indeed.
All right, okay. Thank you.
Now, the effect of this policy is that disabled people are split in effect, if not expressly, into 2 cohorts. In the first cohort, there are those who are disabled accessing one of the relevant benefits and have already been assessed as LCW. And that happens before they decide to move to tertiary education. Such extant beneficiaries, I'm going to call them existing claimants, keep their entitlements. And you can immediately see that if that is the fact pattern, that group is going to be more likely to embrace mature students, those who had to seek work or seek benefit for some substantial period of time before they...
What age do you say you have to be a mature student?
older than merely a school leaver progressing in their first year or a later year. I mean, there's obviously no cut-off point. You don't have to be 25 or 27.
Okay.
It's just going to be a cohort that is, on balance, likely to be substantially older than those who seek to move to university, either immediately after school, so fresh school leavers, or with the benefit of a gap year. And the facts of this case sadly illustrate that a year may not be enough to establish entitlement to LCW and therefore universal credit, given the thicket through which you have to get.
So more likely to be 20 and over.
Correct.
Yeah.
Now the
But there's
intention.
no indication of the numbers and so on, the absolute numbers. We've got nothing about that at all.
Beyond the evidence from Mr. Butler, on behalf of Disability UK, who's given some ranging numbers, and I think it's around about paragraph 16 of his first statement, there is nothing from the Secretary of State at all to quantify the number of existing claimants.
Yeah.
Now that's something that they should know. It's something that should be capable of being monitored on the basis of, first of all, claims for universal credit, and secondly, adjustments that are being made, because, of course, anyone who makes a claim for universal credit has to keep the DWP appraised of any change of circumstances. Going to education is a change of circumstances, at which point your universal credit has to be recalculated to take account of the amount of the maintenance to which you're entitled. So there are all kinds of triggers in the system that should generate data saying this person has moved to education, this is how they're benefited.
And your point is going to be in due course is that the fact that there's a benefit for the 20 plus age group, and conversely no such benefit for the below that in school and or under gap year, is a factor that they should have taken into account into the EIA, and they haven't.
It's both a factor that's relevant to the EIA, precisely, my lord. It's also the basis of ground 3 and the challenge in ground 3, which we just anchor straightforwardly in common law arbitrariness, not discrimination.
So, but you're not appealing the judge's findings in relation to Article 14 and age discrimination. So we have to consider that ground against a background of unappealed findings,
Well,
that there was no unlawful discrimination in this case, whether on disability or age grounds.
the relevance of the protected characteristics is first and foremost in relation to the PSED, because it obviously triggers the...
Yes, I've understood your PSED ground. I was just...
In relation to irrationality,
Yes.
we don't ground our rationality challenge in Article 1 or Article 8 read with Article 14.
No.
We don't want to get into the whole Flemnos debate.
You're not into Article 14, you're not into the Equality Act.
No,
Or
we're
Flemnos.
just straightforward common law
Irrationality.
rationality.
Okay.
And that's because, and I've had this debate with my Lord Justice Lewis many times, we're not sure that there's much of a difference, so we don't want to...
Do we? Have I said that? Oh, God.
You certainly have.
For what reason did I say that?
We had debates about manifest unreasonableness, etc., and the circumstances in which it applies to benefits legislation. Totally accept it's a high bar in relation to an attack on social security legislation. You get to exactly the same question at the end of the day, and we're content to get to that question through the common law.
Yeah, you have to show us the principles then, because you put it as irrationality, which is one thing. There are cases about common law, in inverted commas, discrimination, which aren't, as I could see it, on a quick look in the bundle, and if you're relying on those, it would have been helpful to have had those.
I'm just making a good old-fashioned Cruz and Johnson challenge.
Okay.
Right.
You can challenge a bylaw, secondary legislation, on the grounds that it's arbitrary or capricious.
Yeah.
That's a rationality. My learned friend has cited buckets of case law saying how high that test is directed at...
But that's what it is, it's arbitrary or capricious.
Yes.
And you can test, you say, the arbitrariness or the capriciousness because you look at the differences in the groups of people who are affected by it, adversely and beneficially. That's it simply.
Absolutely.
And no, it's not rocket science. It's
And that proposition is matadine. That's how you get
Yes,
into
matadine.
propositions.
But that's not in
That's
the
not
bundle.
in the bundle.
Well, with respect to given the panel, I didn't think it needed to be.
All right.
We can supply it. I don't think there's any dispute that there is such a principle at common law.
And you'll remind me of the paragraph in your skeleton which refers to matadine in due course as well.
It's not cited in the
Ah,
we
that's
just
why.
put the case as irrationality. But with respect, the citation of authority doesn't actually add to the potency of the point or not.
Okay.
So you have these two different cohorts of people who received markedly different treatment after the regulations were made, and at the request of the SSAC, calculations illustrating that difference in treatment, illustrative calculations, were produced. And I don't know if you picked those up in the bundle.
Speaking for myself, no.
No.
Right, well, maybe just to give you a taste of what's to come, I
Yes.
could just show you that.
Please.
It's in supplementary bundle, tab 6. Page 208.
No, this is.
This is a table.
Yes, now these are various scenarios. I'll show you more of the details.
Well, tell us what the table is. Who prepared it? Is it a government document? Is it your
Prepared
document?
by the DWP
Right.
at the request of the Social Security not appeal committee, was it? Advisory committee.
Yeah. SAAC. Yeah.
SSAC. Yeah.
They asked for these scenarios to be produced, and what they illustrate is the impact of the no new claims policy on various different categories of person.
And when was this done, please?
This was done in September 2020, so after the EIA was prepared,
Yeah.
after the regulations were adopted. And you can see the relevant difference in treatment is in relation to the students who are not living with parents, because whether or not you live with a parent or not might affect whether or not you're entitled to
It'd
housing.
be helpful if you could give me some sort of guide to the exchange of correspondence or request for which this information. It's very difficult to pick it up
I'm going to
without
take you through.
advance
I'm going to
notice.
take you in detail through the correspondence.
Right, okay.
So you're going to get the
So
full
for now,
content.
you're just showing us the
Just showing
different
you the
cohorts.
table.
Just showing you the calculation.
Yeah. Okay.
And the relevant contrast is between 4, which is the position of my client in effect, not receiving UC, disabled, in education, own accommodation, paying about £500 per calendar month rent, no entitlement, and you see what you get is the maintenance loan, etc.
Yeah.
Contrast with 6, a disabled person who's already established LCW, retains entitlement, and the amount of retained entitlement changes, and the amount that you get depends upon whether or not you're over or under 25, because that affects the basic levels of universal credit. And you see, if you're under 25, you retain an entitlement of about £4,500. If you're over 25, you retain an entitlement to about £5,500. Now that puts financial numbers on the impact of this policy as between people in and outside the various cohorts.
So I'm just looking at the box, which I didn't see this in your scan. It would have been helpful because we do a lot of pre-reading. But in the box under 25 opposite 6, you've got the UC allowance, the standard allowance plus the housing element allowance. So you get 10,000 more if you were on universal credit.
No, isn't it the 4,500
Correct.
and the
Oh, hang on.
5,400 in the middle of the
That's in the middle
of
right.
each box?
Okay.
Right. Those are the critical numbers
It's
that you.
the bit that says
Identify.
will retain entitlement to.
Okay, right.
After the adjusting calculation, that's what you get.
Okay.
And it can be contrasted with the figures in box 2 or scenario 2, because this explains what you got beforehand. So box 2 is disabled, not in education, in own accommodation, paying rent, so they're not debarred by being in full-time education. This is the basic typical entitlement you get. You'll see that the amounts have reduced from about 10,000 or 11,000 down to about 4,500 or 5,500. So that's the scope of the disadvantageous treatment. We don't know, because the Secretary of State hasn't gathered any figures, the numbers of people in the existing claimant box or the numbers of people in the new claimant box, either new claimants who've made claims and been refused them, or, if you like, suppressed demand, people who might make claims, might be eligible to make claims, but haven't because of the current setup of the rules. So we can't extend that £4,500 to £5,500 beyond the point that Mr. Butler makes, where he does a modelling by comparing ESA and UC numbers and says it might be about 5,000 people per year, which means that the impact of this is in the order of magnitude of £20 to £25 million What's the basis for the difference in treatment? It appears to be twofold. Firstly, it's said that new claimants would ordinarily have their needs met through the student finance system, as well as additional support from the Disabled Students Allowance, DSA, or discretionary bursaries or grants made available to disabled persons. The Miss Garrett's statement, first statement of paragraph 23, page 118 of the supplementary bundle. So that's the default, but it said that existing claimants would be deterred or practically barred from moving to tertiary education if they risked losing their entitlements to benefits. So in other words, what is accepted, and we can see by reference to the numbers why it's accepted, is that someone having the choice of tertiary education but being £4,500 or £5,500 worse off, and having to take out loans in substantial amounts, as well as, if there is available further financial help from the family, might be deterred thereby from actually entering education. We agree. But the deterrent in our submission arises whether or not you've established the claim in other
circumstances. That's a choice for the Secretary of State. She has decided that if you're a student, you basically get the student support system. She has decided, and it's primarily a matter for her, that for one group, she doesn't want to risk them, saying, I'm in work, I can stay where I am, I won't try and better myself and earn even more by going to do a course of study, and so on. And you say, well, that's harsh. Why don't the other people, because they'd be deterred, their life is just as tough, why are they being deterred? But isn't that the whole nature of the choice that the Secretary of State has to make in this?
I can see I'm going to have a hard time with my law when we come on to the rationality argument.
But you're still doing the introduction.
But before we get to the rationality argument, that is nevertheless the first area of inquiry under the public sector equality duty. And if you haven't fully investigated that, if you haven't fully conducted the relevant Tameside-like inquiries that were accepted to exist in...
You haven't got a Tameside claim, have you, in this appeal?
We have. We pointed out that the public sector equality duty contains within it duties of investigation. We've cited the relevant
that's
provisions.
different. It's part of section 149. There's not a separate freestanding...
No, not a separate...
okay, sorry, right. So it's just section 149.
There's a PSED specific Tameside style duty.
Yeah, we don't need to get into Tameside. It's not relevant to section 149. Either 149 properly interpreted has those duties or they don't.
That's my case.
Yeah. So this is the first area of PSD investigation, you say, is the justification for the policy.
Absolutely. You've got to investigate the relevant matters and the relevant advantage, disadvantage, and how it can be mitigated. And these figures put concrete shape on the nature of the disadvantage and concrete shape on the nature of the deterrent effect. And the deterrent effect will mean some or more disabled people will be deterred from going to university, and that will entrench the position established by statistics supplied to the Secretary of State as far back as March 2017, that there is already aberrant take-up or a differential take-up in tertiary education comparing disabled people and non-disabled people. 33% or thereabouts of the able-bodied population go to tertiary education, and it's a figure in the teens. That's even before the policy bites. And that's the context for the assessment.
Okay.
So the no new claims policy would and should generate a series of questions, not just about its rationality, but also about the compliance of the PSED in those circumstances. Now, if that wasn't complication enough, we've got the whole set of complications generated by the change in the relevant regulation. And there are three facets of what is, I think, accepted to be defective implementation that are relevant. The first facet, and I think this is common ground, is that the no new claims policy was never in fact implemented by the 2013 regulations.
Because there was no requirement for a determination, you just had to make your claim and then be a...
Absolutely. and that there was no trace of it under the regulations, and indeed that the no new claims policy was contrary to the duties under the regulations. That's the conclusion in Badu, and that can only be the explanation for why, having not contested permission, the case was conceded as it was. You can infer, I think quite safely, the Secretary of State accepted unarguable.
Well, she would have changed the regulations if she thought she was on a winner.
Or indeed, even if she had an arguable case.
Yeah.
Because the DWT frequently...
All right, so that's the first defect.
That's the first impact. And that's why what is conceded in causa is relevant, because you'll see that the challenge in causa was to both the interpretation of the 2013 regulations and its encapsulation in the written policy document, which is the written policy document that goes back to 2018.
Yeah.
The second factor is this: when having a second stab at implementation of the no claims policy, it is accepted that there was a workaround in that policy, because it allowed a very well-advised claimant to circumvent it by means of triggering a WCA under the scheme of employment support allowance. Most young people won't have the NI contributions to actually get the grant, but by applying for the benefit, you can trigger a process in which you are credited with national insurance contributions.
And that's what Mr. Keyes did.
That's what he eventually did. The workaround plainly works through the persistence of his mother and his advisors.
Well, he had a tough time because a couple of times they kept closing it and they didn't deal with him fairly. And he had 18 months when he was sent all around the houses, and that shouldn't have happened. And the Secretary of State should apologise, and I think she has apologised.
She has apologised.
He didn't need to go through that on top of everything else. But we've got
She's apologised fulsomely. She's compensated. She's backdated. But it remains a very graphic illustration of the thicket that you have to get through in order to advance your claim. And the third facet is that because of these mistakes in the transposition of the original intention, the 2020 regulations were introduced in a very great hurry, 3 days of the concession through to the instrument being made and laid before Parliament.
Yeah. Probably as a result of the timetable in the judicial review.
Absolutely, my lady. With the result that there has never been any consultation on the new claims policy at all. And that much must be common ground.
Unfortunately, there was no obligation on her to consult.
No, but
as you concede,
when we get to bracking, we're going to see that whether or not there has been a consultation is a highly germane factor as to whether or not the PSED has been discharged, because by giving parties an opportunity to put forward evidence and submissions, you have the basis on which to discharge your duty.
It could be one way in which the underlying aims of the PSED are met. I understand that,
So those are the material circumstances. There were a couple of other points, forensic points, to note in that broad setup. It's not suggested that there was any EIA in 2013 or 2012.
Yep.
And we can therefore assume that there wasn't one.
Yeah.
Canada would have required its disclosure otherwise. So the silence there is informative. And equally, we haven't seen any submissions or equality impact assessment from 2017 when the Badu decision landed. And what you'll see when we get to the chronological review is that the Secretary of State did consider her options, as she was at the time, at the point in time of receiving the first tier tribunal's judgment. And one of the options considered was better reflecting the original legislative intent. But even then, when confronted with a decision saying the policy is unlawful, and you're considering whether or not to introduce a legal means to the policy, there wasn't an EIA at that stage.
Okay.
And we haven't seen any submissions or materials in relation to that reconsideration. We just have Ms. Garrett's evidence in relation to it. So those are the general introductory remarks. Can I then turn to the second topic, which is the statutory framework? And can I start with the advisory committee? The legislation governing its operation is contained in tab 1 of the Authorities Bundle, which is the Social Security Administration Act 1992. Section 170 creates the committee. Its function is effectively to be consulted upon and make submissions of on regulations in scope of its subject matter. You see that from section 171, page 16. It's not, I should emphasise, an equality watchdog. And then section 173 which is at page 17, contains the urgency exception. But even when the urgency exception applies, under 1732, there's still an obligation to discuss the matter and refer it to the SSAC as soon as practicable after making the regulations, and that's what occurred in this context.
Yeah, but the SAAC did agree that they didn't want to refer and they didn't want to take action on it, and there's no complaint about that, is there? Right, okay.
But nevertheless, the material they generated and its timing are relevant to the issues in this case. So that's the first thing. The second is the public sector equality duty, which is in tab 5, section 149 of the Equality Act, page 47 of the Authorities Bundle. It bites upon a public authority. There's no doubt that that is the case here. The duty is to eliminate discrimination.
No.
Due regard.
Due regard to the need to.
Due regard to having need to.
There's a very big difference, Mr. de la Mare.
I appreciate it. Forgive me, I'm just proceeding too quickly. I was aware of that and I wasn't seeking to mislead my Lord. Fat chance of that in any event.
Sure, I have now woken up. Now I know it's Wednesday.
Anyway, it's a due regard
The due regard.
The court's very familiar with it.
Of course you are. The due regard duty is directed to both elimination of discrimination, but also, importantly, B, advancing equality of opportunity.
Yeah.
And then C, and it's not really in play here, fostering good relations. And then what due regard means is expanded by 1493.
Yep.
Won't repeat that, given I'm probably engaged in motherhood apple pie review. Let's go to bracking, which I suspect is in a similar category.
Yep, but still.
And I'm conscious here that one of the dangers with public sector equality duties is precisely that sort of familiarity breeds contempt situation. When one comes to look at the facts of bracking and compare them and contrast them to this case, bracking was a claim that succeeded under the SED. The facts of this case are starker and clearer than the facts of bracking. Everyone always quotes paragraph 25. They never look to what actually happened in the case and how those principles were applied.
Well, I suggest you read some of my judgments, Mr. de la Mare, because I start off with that. What did bracking decide?
I rather think I might have done so.
Well,
too, but there we are.
I'm back in motherhood and apple pie, but then that's going to make my task so much easier.
Let's start at 25 then.
Paragraph 25.
Hang on, I haven't got bracking yet. Which tab?
21.
21. Thanks.
21.
Is it not reported anywhere?
I don't believe it is. Now, as you'll recall, since you've both read it so many times, bracking was a disability case. It was about a closure of a fund designed to support independent living. It had been preceded by a very extensive consultation process in which many affected parties, including advocates of the disabled, had made detailed submissions with detailed materials. And the complaint was not a lack of investigation, because all the materials were there. The complaint was that the materials hadn't been adequately taken into account and reflected in the equality impact assessment. The principles are set out and summarised starting at page 378. Forgive me, I do want to just unpack these principles because I want to flag which ones are relevant in the present case. First of all, as stated by Lady Justice Arden in the nomenclaturally appropriate case of Elias, the duties are an integral and important part of mechanisms for ensuring the aims of anti-discrimination legislation. And 2, C. Bapio, an important evidential element is that in the demonstration of the discharge of the duty is the recording of the steps taken. We're going to see that that's a problem in the present case. 3, the duty is on the minister or the other decision maker personally. Here it must be the minister making the regulations. 4, this is particularly germane in the present case. A minister must assess the risk and extent of any adverse impact and the ways in which such risk may be eliminated before the adoption of the proposed policy, and not merely, and one can hear the Lord Justice saying it, not merely as a rearguard action. And we're very much in the terrain in this case of rearguard actions, given the antiquity of the policy at the time it finally came to be subject to analysis under the PSUD. 5. There are the following 3 propositions identified by Lord Justice Aikins in the Brown case. Must be aware of the duty to have due regard, not an issue here. 2, the duty must be fulfilled before and at the time when a particular policy is being considered. And 3, the duty must be exercised in substance with rigour and with an open mind. It's not a question of ticking boxes. Duty is non-delegable, and 5, it's a continuing one. Good practice to keep records. 6, general regard to issues of equality is not the same as having specific regard by way of conscious approach to the statutory criteria. 7, and this was particularly important in that case, and we would submit here, officials reporting to or advising ministers on matters material to the discharge of the duty must not merely tell the minister, decision maker, what he wants to hear, but they have to be rigorous in both inquiring and reporting to them. And then 8thly, if one reads the whole of paragraph 8, you'll see there is an analogue to the Tameside duty of inquiry. And that is found in the reasoning in the case of Hurley and Moore. Lord Justice Elias, a noted equality expert, I hardly need tell you. And the end conclusion is that he accepts Miss Mountfield's submissions that there was, in effect, a Tameside-style duty. So it's those principles that are required to be applied. Then let's look at how they are applied, in fact, in that case. And the analysis picks up on that front, around about paragraph 40. Well, that's the first passage I want to show you. Because I think the analysis at 40 is relevant in the present case, given the different cohorts of disabled people who are affected, advantaged or disadvantaged by the policy. Nevertheless, the overall consideration is the position of disabled people overall.
How the balance is to be struck is for her, but she must fully appreciate the impact on those adversely affected.
Absolutely. You can't hide from the impact. You've got to own the impact. And then at 59 to 60, which is at page 386 of the bundle, you get Lord Justice McComb's conclusion. The Act imposes a heavy burden upon the public authorities in discharging the duty and ensuring that there is evidence available, if necessary, to demonstrate that discharge. It seems to have been the intention of Parliament that these considerations of equality of opportunity, where they arise, are now to be placed at the centre of formulation of policy by all public authorities, side by side with all other pressing circumstances of whatever magnitude. But they're not to be an afterthought, and they're not to be analysed after the policy has been long settled and long implemented. And then at 60, the conscious approach is re-emphasised, and in the absence of evidence of a structured attempt to focus on the details of equality issues, the decision maker is likely to be in difficulties if their decision is challenged. The key word there is details. 61, conclusion, that the problem with the Secretary of State's case advanced by Ms Bush is it invites us to draw upon the facts as a whole rather than upon hard evidence. In my view, there is simply not the evidence, merely in the circumstances of the Minister's position.
And is that why you emphasised the period between 2013 and 2020?
It is.
Because that is a period in which such evidence would have been capable of being collected.
Absolutely. When we come to look at the equality impact assessment itself, it envisages collecting such evidence in the future, except there are deficiencies in the available evidence at the point in time of the decision. But it doesn't acknowledge the fact that they've been operating the policy for 4 years and haven't gathered any data.
But looking at 62, it looks as if, but you say this is wrong, that the real problem here was that the Minister didn't realise that independent living might actually be put at risk for, what's the phrase, a large number of people. And the question really is translated into the facts of this case. Was the Secretary of State aware that there would be a severe financial impact on certain disabled people? That's what we're going to have to look at, isn't it?
We're 2 stages earlier than Bracking. There wasn't a consultation, so those most affected weren't even asked for their views.
Yeah, but that's a different box.
Well, no, it's the evidence hasn't been gathered.
Yeah.
Point 1. Point 2, even the Secretary of State had available to her at that time the ability to calculate the kinds of scenarios asked for by the SSAC, but didn't do so. The Minister wasn't told that the difference between being an existing claimant and a non-existing claimant is that you would have to find between £4,500 or £5,500 from discretionary or charitable bursaries or donations. And that's obviously relevant because when one looks at the regulations when they're passed, it has the standard rubric saying there's been no impact assessment because no impact on the public, private or voluntary sector is anticipated. Yet the Secretary of State's entire cases, the public sector, the private sector and the voluntary sector are going to have to stump up to the tune of 25 million to make up the money I'm not making available. So we're at a stage well before Bracking. This case has fallen over before we even get to those principles. But it's necessary to see the rigour with which the court is approaching the question of evidence. 64 is important because it shows that this case is anterior to any question of rationality, which is why I run this ground second. It may well be, if the questions are posed and answered, that the Minister has an answer to any challenge through the framework of rationality, but that doesn't stop the fact that the PSED first requires the relevant questions to be asked. So back to my Lord Justice Lewis's sally against my rationality.
No, I'm just trying to test things. I've got no views at all at the moment. I've only just worked out it's Wednesday, so at the moment I'm just listening carefully to what you're saying.
So paragraph 64, and that's the essence of why Lord Justice McComb reaches the conclusion he does. It's also useful to look at the judgments of Lord Justice Kitchen, as he then was, and Elias. 68 is a relevant passage from Lord Justice Kitchen's judgment. He wasn't prepared to infer that the Minister properly appreciated the impact of the proposals on the substantial group of disabled persons currently benefiting from IAF. And that was notwithstanding heaps of consultation responses and an attempt to summarise them in the EIA. Do not consider that the Minister was given adequate information to enable her properly to assess the practical effect of the proposals. And then Lord Justice Elias adopts a somewhat different attack to the previous 2 Lord Justices. He emphasises at 72 the importance of conscientious and deliberate fashion in implementing the objectives. Then he identified 2 facets of particular concern to him. The first at 73 was the Panglossian nature of the evidence. and there's more than a whiff of that Panglossian, everything will be fine, you'll find the money elsewhere, other funds will proceed to plug the gap in the way that the Secretary of State approaches it, in this case, though at a much, much higher level. And when we get on to ground 4, we'll see that, ground 3, we'll see that some of the Panglossian predictions are completely irrelevant, like disability support allowance, which doesn't meet living costs. It's not paid to you, it's only used to meet particular special capital requirements, effectively special equipment. It doesn't answer where you're going to get your next tin of baked beans. So no answer at all. But then I think the nub of Lord Justice Elias' reasoning is at 75. Where he effectively says the duties and their serious nature aren't written in large enough letters in the decision-making process. The decision-maker didn't have her attention drawn to the positive obligation to advance equality of opportunity, or the terms of the Nations Convention on the Rights of Persons with Disabilities, which ought to inform the scope of the PSED. And then he concludes there was no evidence that any of these considerations were in the mind of the Minister. Indeed, the primary focus of concern appears to have been on achieving fairness as between those who benefit from the fund and those who do not. And that consideration, is it fair, seems to be the primary consideration here, without actually focusing on the entrenchment of disadvantage and the loss of equality of opportunity. So that's Bracking. The only other case on the PSED I'd like to show you is one of the many Good Law Project cases, Authorities 36, page 927. And it's paragraph 105. Which is at page 927 and following. Because 105 through to 107 are a further useful summary of the relevant principles, a bit shorter than the Bracking summary, but one that places particular in emphasis on the Tameside analogue at 107. What's required is the taking of reasonable steps to make inquiries about what may not yet be known to a public authority about the potential impact of a proposed decision or policy on people with the relevant characteristics. So that's the law, that's my second topic. Chronological review. Now, by all means, get the cattle prod out at any stage and tell me that I'm showing you materials that you already read and thought about, etc. Because in part I'm going to show you the primary legislation. Maybe you can just rattle through that. The starting point is the Welfare Reform Act.
The 2007 or the 2012?
2012.
Okay.
Tab 4.
Tab 4.
Establishing universal credit. You can see from subsection 3, there's a standard allowance, and then D, there are amounts for other particular needs or circumstances. And what's called LCWRA is effectively one of those types of increments to be contrasted with LCW. Claims could be made by single persons or members of the family. It's single persons that are relevant. Section 3, single claimant is entitled if you meet the basic conditions and the financial conditions. Basic conditions, section 4. And the relevant condition here is D, you're not receiving education.
So Parliament started off by saying then that UC wasn't contemplated for those receiving education, subject to those who were made the subject of exemptions.
Correct.
Yeah.
And the regulation making power is in 4.2, and then 4.6 provides that there's a regulation making power to address what receiving education means and the circumstances in which a person is receiving or not receiving education. Now, all of these basic conditions are fleshed out by regulations. The one that's most litigated, I suspect, is in Great Britain, the sort of habitual residence test, about which there's endless cases. So it's the regulation making power that's critical, but can we just briefly look at some other provisions of this Act? Section 8, turning on to page 39. explains the system of calculus. And then section 12, page 44. This is the basis for the LCWRA increment, especially subsection 2. Again, that's to be fleshed out by regulations. And you can see in subsection 1, and then 37, which is at page 45. This is the definition of limited capability for work. And you see from subsection 3 the question of whether or not someone has LCW or LCWRA is to be determined in accordance with regulation. So that's the framework under which the 2013 regulations, to which we now turn, tab 7 of the authorities are made. Receiving education is defined in subsection 12. Can I ask you to note, for reasons that will become apparent a little bit later, the use of the term qualifying young person, which is a term of art used to condition entitlements, etc. That's a term of art relevant to section 12, and through it, it's relevant to the entitlement of a parent, effectively, to receive universal credit for a child who's still in secondary legislation. It sets the boundaries between those entitlements. And then section 30, regulation 13 defines what is a course, and then we come to the crunch regulation 14. And at this point, can we break off and go to the regulation as originally enacted? And you'll see it's not 14.1b, it's 14b at this juncture. You have the simple requirement: you're entitled to attendance allowance, DLA.
So where's
Tab 8.
Tab 8, page 97. I'm so sorry. And as such, on the face of the regulation, whether or not any one of these conditioning factors is satisfied is a matter for investigation before deciding to admit the claim. The decision maker has to investigate whether or not you have DLA or one of the other benefits, and whether or not you have a limited capability for work using the powers of assessment under the regulations. And if we then go back to tab 7, we can...
Can I just have another look at this original one? Yes. So A, B, C, D said they're all alternatives.
Correct.
And it's just B. But B has got two things. So is entitled to attendance allowance and has limited capacity for work. And the problem is what that means. If you just looked at the statute, you know it would have to be determined. But there are other complicated bits which say you're treated as if you've had a determination. Is that how it's going to work?
That's correct. We can come on to looking at Schedule 8. So Schedule 8 effectively exempts you from having to satisfy that in certain narrow circumstances. And if we go back to tab 7 for the rest of the regulations, you've then got regulation 27 that deals with LCWRA element. And in most cases, this is the first point in time where there will be an LCW assessment under universal credit, because in most cases, the only point at which limited capability for work is relevant is if you're asking for an increment. And
so
that's why...
Reg 27.
That's Reg 27. Yes. And then at page 61, you've got the provisions dealing with assessment, regulation 38 onwards. the question of whether the claimant has LCW or LCWRA is to be determined in accordance with this part. Regulation 39 provides for an assessment either under this regulation or under Part 4 of ESA, which is...
Just pausing there, I don't know how relevant this is. Reg 39(1) does have appears to have its own definition of limited capability for work in terms of an existing determination. I'll just make that point because
it governs the means of proof. So what Regulation 39(1 is saying, you can prove the status of LCW in one of two ways. You can prove it if it's already been proved by an assessment under Part 4 of the ESA regulations, or an assessment under this part.
Right.
Or, so two different modes of assessment, or you can prove it if you can show that you are to be treated as having limited capability for work. And that's where Schedule 8 exactly comes in. So there's two modes of proof. There's either factual assessment under this regulation or under the parallel provisions of ESA, or there's treatment under Schedule 8. And then you can see that, my lady, at subparagraph 6. Subject to paragraph 7a, a claimant is to be treated as having limited capability for work if any of the circumstances set out in Schedule 8 apply.
Yes.
And then Regulation 40 and following provide for the process of determination. Regulation 41 deals with when an assessment may be carried out. And you see 41(1)(a) may carry out an assessment where it falls to be determined for the first time whether a claimant has limited capability for work or LCWRA, or there's been a previous determination and the state wants to work out whether there's been a change in circumstance. And then I think we can just note Regulation 69 deals with the specific issue of how do you calculate student income, and in particular student loans and postgraduate loans. So it treats them as income and effectively assumes what it can be applied for and got is got. See that from 69 and 70, 71. Nothing turns on the detail of that. And then we've got the terms of Schedule 8.
Where are they?
They start at 83. And you can see an example of the first one is receiving certain treatments. You're getting hemodialysis for renal failure, getting treatment by plasmapheresis, regular treatment by parenteral nutrition, in other words.
Sorry, where are you reading from?
It's 84, actually.
84.
You've got this odd thing where this part comes at the end rather than the beginning.
I see.
Which
Schedule
I was
8.
just brought up very simply. You looked at the top and it told you the heading, and then you went down to the next bit. But
Yeah,
who
it's
was I
confusing.
to?
It certainly confused the hell out of me as well.
Well, usually it's that way in England. You stick to it if you're happy with it.
Well, that's Thomson Reuters, I think. I probably need to
Anyway,
do that with.
So it's page 84.
That's the first example. The second example, para 2, is if you're in hospital.
Yeah.
Yeah.
If you're prevented from working by law, which is mildly interested for COVID regulation fans, and so on and so forth. And none of those narrow circumstances apply in this case. What then of the contemporaneous materials?
Where's the bit that says if you're getting... I thought that you were to be treated as if you had limited capacity for work if you were in receipt of a PIP or a DLA or an AA. Where's that?
No, that was under the old regime.
Yeah.
The old regime said that if you were receiving a PIP, DLA, or attendance allowance, you were effectively entitled thereby to the relevant benefits in question, and that scheme has been displaced.
No, hold on. Then you have lost me. If I go back to 97, 14B, that's the old one.
Oh, I see. I thought you meant the pre-2013 regulations.
No. I thought we were really starting in 2013. I hadn't braced myself anything earlier. And 14B says you've got to have an entitlement to attendance allowance, disability living allowance, or personal independence payment and has limited capacity for work.
Yes.
And that's the bit that I'm just wanting to fill out. This is not a study. I'm trying to work out the jigsaw. So how does and has limited capacity for work?
How does that work?
In 2013.
In 2013, it works exactly as Judge Pointer said in Badu. What happens is you make a claim for benefit. It then falls upon the Secretary of State to assess whether or not you have limited capability for work using the provisions of the part directed at that.
The ones that we've looked at.
Yes, and if at the end of that process it's established that you do have LCW, then your entitlement is established and it's backdated to the date of your claim.
Right.
That's how it works. And with respect, there's nothing unusual about that. There's plenty of things that have to be assessed once a claim has been made before your entitlement is
So there would have had to have been determination. Before you go to the university, you apply for universal credit, you have a determination, it's backdated. There's got to be a determination.
Correct.
It's not an assumed determination.
Correct.
Because you've got these things. You've got to have, your client would have had to have undergone a physical assessment at some stage between having made the claim
Correct.
and getting the backdated benefit.
Let's say I make my claim on the 31st of August when I've got my UCAS results and I found I've got a place. I'm starting, let's say, at the end of September. It takes 4 months for my LCW hearing and WCAA hearing to be convened, and in December the following year, let's say December that year or January the following year, it's determined I did in fact have LCW.
But it will then be backdated.
I then get a backdated claim to when.
But the fact is that you could have made the claim before you went to university and it'd be backdated, but there will be the physical assessment process thereafter.
Correct.
Right, okay.
That's exactly how Judge Pointer said it worked. And given the concession of the case in Causa, that was the basis for the acceptance that there was a duty to carry out an assessment under the scheme of the 2013 regulations, a duty to assess, with which the no new claims policy was inconsistent.
And if you didn't realise that you could get universal credit until after your first term, and you applied on the 1st of January, halfway through your first year, it would be backdated, but only to the 1st of January.
Correct.
Yeah, okay.
Correct. So that's what the instrument says on its face, and anyone reasonably versed with social security would pick that up and say, there aren't many of them, but there are a few people in that cohort, and say, well, you're entitled to an assessment, and the assessment will determine whether the claim made is a good one or a bad one. And that was Judge Pointer's reaction. He said any other conclusion was Alice in Wonderland.
And the date of his judgment?
2017.
And the reason it's so late is because students weren't in the first phase of rollout of universal credit, and the relevant universal credit pilot provisions didn't apply to students until I think around about 2014, 2015.
So it just took 3 years for the obvious to be recognised. Yeah.
Exactly so.
Yeah.
Because of that delay, the case took a while to come to fruition. So what I just wanted to look at last before leaving the 2013 regulations is what happened in the run-up to them and how they were analysed. The first set of materials is what's said during the passage of the bill. Mm-hmm. And I accept that all of this is no more than tonal. The reason I'm relying on this material that I'm about to show you is this. There is nothing that constitutes any kind of flag whatsoever as to the existence of the new claims policy. So if it was the Secretary of State's original intent, there was no objective public indication of the existence of that policy. I'm not making some kind of secret policy point. I'm simply making the point that no one would have had any cause to make any submissions about the new claims policy, not least because it was inconsistent with the duties arising under the regulations that were made.
I'm not sure why we should be looking at this parliamentary material. Then your case is that there was nothing in the public domain to alert people. If Ms Clement wants to produce material that did alert people, then isn't it for her?
Well, there is one interchange that her client says does constitute pre-regulations indications of the existence of the no new claims policy. Let me deal with that very briefly. I can give you the references anyway. I won't take you to the materials if that's my Lord's approach. The references are as follows. First of all, there are the Hansard passages in Supplementary Bundle, tab 8, page 245, in which the relevant minister, Mr Grayling, basically said the intention behind the the bill, as it then was business as usual to continue previous entitlement. The bill briefing notes, supplementary bundle tab 9, page 254 at 255, which are to similar effect. And then perhaps it is worth turning it up, the explanatory memorandum of the SSAC, which is in the supplementary bundle
256.
Correct, my lady. And the relevant passage is actually at 262.
But this was a memorandum dealing with the whole gamut of
the whole
everything.
Everything. But the relevant bit at 262, headed Education, Exclusions and Exemptions, deals with effectively Regulation 14. And all it says at 36 is, as now, there are a number of exceptions specified in regulations. Third bullet point, disabled students who are single or whether are part of a couple and one of them is both, or both of them is disabled. Nothing to indicate.
Well, I haven't found a bit about disabled students yet.
263.
Right.
Nothing to indicate an intention to materially alter entitlement.
So what do you get? This is very general, Mr. LeMay. Does this really help, actually, the problem?
Well, in my submission, it does matter. It informs when it is that materials start percolating out in relation to the PSED, when it is the policy crystallises in sufficient form that people can say things about it. And if the policy has been operating, as we're told it has been, since 2013, but no one knows about it, that's going to affect what people have said about it, and when. And then at tab 14, we have the SSAC's, the explanatory memorandum to the Universal Credit Regulations, and again...
Page? Sorry, we don't have tabs.
Page 279, my lady.
279.
And it's points 7.5 through to 7.6.
Sorry, what are we looking at here? The explanatory memo
To the Universal Credit
to the regs.
To the regs.
I misunderstood.
Prepared, as you see from paragraph 1, by the DWP and laid before Parliament to help explain
Yeah.
the regulations in the scrutiny process.
And paragraph 7.3?
7.5 to 7.6.
Hold on, let's just have a look at them then.
Page 282.
Yeah.
So the basic position is you are not entitled to it. And that's the point made at 7.5, if you're in education.
Correct. There's nothing, again, it's a dog that doesn't bark. There's nothing to flag the existence of the no new claims policy, even in the passage of the regulations themselves, even in the passage of the explanatory memorandum explaining Regulation 14.
Is that the only relevant
It is.
part?
You can word search this particular document for the word education or disabled, and nothing else comes up. So we have a situation that I've made my point. No discernible trace of the no new claims policy. Public statements, such as they are, convey a general impression of business as usual. And we have clear evidence from Miss Garrett that that was the internal and uncommunicated policy intent of the Secretary of State.
What was?
That there should be no entitlement if you're making a new claim.
Right.
That's the clear evidence of Miss Garrett, doubled down on by Miss Clement in her skeleton argument. She says it's impossible for us to suggest otherwise, that there was that intention that went back to 2012, 2013. But it's not patent on the face of the measure. It's not patent from any of the public materials.
We know it's not patent, and we know that it's wrong. And we know that even the Secretary of State ultimately accepted that it was wrong. But as a matter of fact, she might be mistaken, but she is a human being. Did she think, goodness knows how you would say, but did she think, was her state of mind or the departmental state of mind such that the assumption was that once this was rolled out in 2014, that people who were trying to make new claims wouldn't be caught or not? They might have been mad, so to think, but is that physically what they thought? Are you challenging that finding?
Don't have to, so I'm not going to.
No, but it doesn't matter whether you don't have to. Are you saying you're not making submissions on it, and therefore it's up to
Not
us?
challenging it.
I'm not
just
challenging.
said.
You're not challenging it.
What I'm saying is it's the clear evidence that that was the position. All that we can proceed upon is what was overt. That's enough for my purposes.
Yeah, but you're not challenging the fact that internally the department believed it was able to operate a policy of no new claim.
No, but it's my learned friend who has to accept the logical consequences of that. Because if it was the internal policy at that stage, then that stage, 2012, is when the PSED first crystallised. And what is absolutely apparent on the evidence, and is accepted, is that there was no PSED assessment of this material change compared to the previous position.
Well, firstly, I don't know whether there was an equality impact assessment of the 2012 version of Regulation 14, but secondly, you simply aren't challenging that if you look at your claim form. I understand you say it may or may not be relevant to the what you are challenging, but if you read Section 3 of your claim form, you are challenging a decision, the decision to refuse under the new regulation. And as part of that, you're saying she shouldn't have refused under the new regulation because the new regulation is unlawful.
But the adequacy of the EIA in relation to the 2020 regulations is affected by what has gone before. And it is material that this is a policy that by this stage is 8 years old, and yet 8 years on, this is the first assessment that occurs, so far as we can see.
Right.
Those are the facts.
That's your point, okay.
That's the facts. So further back my learned friend pushes it, in effect, the longer there has been a breach in failing to conduct an EIA.
I don't think it matters. We're not assessing whether there's a breach. I think it would be more helpful to me if you're saying there are 8 years when you've expected them to have lots of material and there isn't any trace of it. Because what you're challenging is the breach for your decision.
My lord, I'll put it that way, my lord.
Yeah.
I think that is, to be fair, how you did put it earlier.
It is.
So 8 years of missing information. Yeah. Right, got it.
Now, I should just address, as I said I would, the one piece of communication that said to predate the regulations, that is said to identify the existence of the no new claims policy.
Yeah.
It's paragraph 25 of Miss Garrett's witness statement. That's supplementary bundle, tab 6, page 119. What is said is that the summary of the responses to the SSAC reveals a query posed by Disability Rights UK, which noted that students on DLA could claim income-related ESA at present, but would only be able to claim UC if they also had a limited...
I'm really sorry. Can you just say where you're reading from? I'm on 119, but which
Paragraph 25.
25, thank you. Shall we just read that?
Of course. Now, if one goes to the relevant document, and it's
130.
130, exactly, my lord, you can see that 3 questions, 3 bullets are raised in relation to the third point.
Yeah.
And they're in relation to Regulation 5, dealing with qualifying young person, and exceptions to condition of entitlement education, Regulation 12. See that from the question. They're not about Regulation 14. The first question is about the change of the definition of qualifying young person. And then the second bullet point is where Disability Rights UK has said something. They've commented that this provision effectively restricts the ability of young people to complete their education. Now, it's absolutely apparent when you read this that this is about completing your education at secondary education, because it creates a deterrent by the change, the narrowing of the definition of a qualifying young person. It's absolutely nothing at all to do with Regulation 14. And then the third bullet point, which is not a disability rights point, it seems to be a further freestanding one. Students on DLA can claim income-related ESA at present, but will only be able to claim UC if they also have a limited capability for work. And all that's being said there is that the substantive second condition has been added to Regulation 14. That is absolutely nothing to do with the second restriction, which is the no new claims policy. It's no part of our case to challenge the need for there to be an LCW assessment. Yet that is all that is being complained about, and it's a theme in the submissions made by DUK, which is that we should go back to the old situation of presumed LCW unless proven otherwise, which is a completely different kettle of fish. The answer to that third point you can see. On the third point, the intention is that disabled students should have access to universal credit, but only when they're entitled to an additional element for LCW for work or LCWRA.
So what does that mean? Does that mean because they've had a determination?
Correct. So in other words, LCW or LCWRA has been established. It says nothing about a bar upon them establishing.
Nothing saying that you can't make a claim for it.
Correct.
That's your point.
That's my point. So, with respect, there is absolutely nothing before 2017 that indicates the existence of the no new claims policy. We can then pick up matters with the chronology, and can I ask you to just make the following note on the chronology, which is in Core Bundle 10, tab 10, page 88. Can you put a sort of dotted line between the 25th of February 13 and the 12th of April 2016? And the dotted line is...
Hold on. Can you give us the page reference?
Yes, 88,
again?
my lady.
Page 88.
Where's
And
the dotted line?
Between the February 13 and 12th of April 16 entries,
Yep.
the dotted line is first rollout of UC to students.
So sometime between 2013 and 16.
Yes. And that's explained by Miss Garrett in her second witness statement, page 215 to 7 of the supplementary bundle, when she responds to Mr. Butler's second witness statement to contextualise the correspondence. And you can see there she explains how it is that universal credit was rolled out to students considerably later, which is why the issue only began to arise in correspondence and then the Badu litigation in 2016-2017.
So the importance of it only began to be realised from 26. Once you started paying it out and they suddenly realised they weren't getting it, that's when questions will arise.
Correct. So it was only in consequence of the commencement of correspondence in 2016 that there began to be a bit of the iceberg above the waterline. And if we could pick up at page 70.
We know when the FTT decision was, but do we know when the decision refusing universal credit was made and when the appeal was lodged before the FTT?
Yes, those dates are in the Badu case. From memory, it's September, one date in September 2016.
So September 2016 was the claim.
That's right.
And then it took between then and September 2017.
Correct. We're going to go to the Badu decision,
yeah, okay.
So I'll give you, my lord, those dates when we
get there.
Yeah. So, if you could turn to page 77 of the bundle, this is Mr. Butler's second statement. The reason I state here is that this is actually the earliest point of the correspondence. And it's 17th of February 2016 when matters start, when he wrote to Miss Norris to ask her various questions, and that received a response on the 12th of April. And
is she talking about there?
This correspondence is then at page.
That can't be right, can it? What she's saying there?
I'm going to show you the emails. You can see that with respect it is right. So the thread starts on the 17th of February 2016 at page 82.
Yep.
With an email from Mr. Butler to DWP operational stakeholders. Hi Elaine, here are various questions. The question that is being asked is effectively this. How will a student get a LCW assessment if the practice of the department is not to conduct an assessment until after 3 months, which is the requirement that you have to wait?
Where exactly is the question, rather than your interpretation of it?
83.
Yeah, which one? Or all
This
of it?
means that about 2/3 of the way down, that a full-time student can only be accepted as having LCW after a work capability assessment has been carried out. Regulation 41 of the regulations would allow a full-time student to be assessed as to whether I think it should be whether they have limited capability to work. However, Regulation 28 would prevent an award of the limited capability for the work element being awarded before a 3-month waiting period. So it's effectively saying, is the system one that requires you to make a claim and then wait 3 months? That's how it would work under a standard universal credit case where you are applying for LCWRA, in other words, the increment. And effectively what's been pointed out is that the regulations have been primarily designed for assessments to support LCWRA, and it doesn't appear that you can get an assessment earlier than the 3 months. And that's the question that's answered at 81.
And he understood it. So I'm just trying to read the whole question from the beginning to the end rather than the bits you've shown us. And he understood it as meaning the way it's going to work is that they'll be getting a decision to refuse their universal credit shortly after they submit it, which means they won't have the opportunity, the 3 months, to get the work capability assessment.
Correct.
So he's saying, how is this going to work? Because it can't work.
Correct. That's the question that is being asked.
Yeah.
The answer that is given, I can't give a better word than this, is a nonsense answer. And the Secretary of State accepts it's completely wrong.
Yes, even to me it was wrong.
And the answer is at 81 to 82, and they're saying effectively, don't worry, you don't have to go through an assessment, you can just submit medical documents. And that's confusion of Schedule 8.
The old system with the new system.
No, it's confusion of how you prove a Schedule 8 entitlement with how you prove LCW. Right. It's completely wrong.
Yeah. Right.
It reveals the Secretary of State doesn't understand their own system at this point in time. But again, it's the dog that doesn't bark, because at no point here does anyone say, you can't do this because we have a policy to say there will be no new claims assessed.
Yeah. But if we forget the words, policy and so on, what we've got at is Ken had grumbled the fact that the way things were structured looked as if students were going to be refused before they got a determination. And he's saying, well, how are they going to get it because they're going to be refused? I
think he's actually asking, are you going to be refused or delayed for 3 months? But in any event, this particular controversy, the effect of LCWRA in Regulation 28, is one of the questions that almost immediately thereafter is answered by Judge Pointer in the back case.
Yeah.
And now let me proceed to show you that. That's page 137.
So this is 2016, these emails.
That's right.
Yeah.
The decision in Badu, you can see paragraph 4, page 132. 13th of September, I think is the date. 3 and paragraph 1 over the page at 133. You can see the date of this decision is the 1st of August 2017, so it's nearly a year later.
So she must have applied on the 13th of September then?
Correct.
2016.
Reasons for the tribunal's decision at 136. The first thing the judge deals with at 9 through to 14 is the Secretary of State's argument that under the regulations properly interpreted, there's no power to assess because you have to have a determination of LCW before you make a claim. This is the argument he describes as Alice in Wonderland at 13. The reason you can't prove LCW is that the Secretary of State has not carried out an assessment. And then the critical thing, 14, that circumstance is a plain breach of the Secretary of State's statutory duty under Section 8(1)A of the 98 Act to decide claims for benefits. In order to make a decision, he has to find all the necessary facts and determine all the issues. And that means, as is gone on to explain in 15 and following, that they have to use the powers of assessment. And it's in the context of how the powers of assessment operate, at 16 and 17, that the judge then addresses the LCWRA issue. And his answer is, yes, it's true under Regulation 28 that you only usually do that after 3 months, see Regulation 28. However, there is no rule that says a work capability assessment can only be carried out at that stage. In other words, in most cases, there is no duty to conduct an assessment earlier, but in this case, because of the gateway conditions in Regulation 14, there is. And it's on the basis of a duty to assess that the case was decided, and of course that duty to assess is what makes the no new claims policy unlawful, as conceded in Causa.
So the illegality is actually the failure to comply with the duty under Section 8. It's not the policy itself that's declared unlawful, it's simply that that way of doing things violates or breaches the duty under Section 8.
That's right, and it's only by the modification of the entitlement conditions under Section 14 that you relieve the Secretary of State from the duty of investigation under Section 8. So running in parallel with the Badu case, we have correspondence between DRUK and the Secretary of State. We can pick that up at page 140 of the supplemental bundle. This is the first emergence of the no new claims policy, 140 through to 141. And effectively, although the policy isn't being named or spelt out, the routes to entitlement are. And effectively it says you've either got your Schedule 8 entitlement.
Where are you reading from, sorry?
It's page 140 to 141. If you haven't read that letter, could I ask you to read it now?
Yeah. So just below the second hole punch, who has already been determined.
You're way ahead of me, my lady. It's the word already, and only the word already, that does all the heavy lifting. That's as far as one gets as to an articulation of the policy. But it's this letter to which Mr. Burns then replies in correspondence that was exhibited to his first witness statement at 47.
So page 47.
Page 47 is his first witness statement, and then the relevant communications at 58. And at 58, you see the first complaint, paragraph starting, however, is about the failure to automatically treat or presume LCW as per the old scheme. And then, in addition, under universal credit rules, as full-time students, they are even denied the chance to undergo the DWP's work capability assessment to determine their LCW. And that's because the policy is now in plain view. It's been litigated through the Badu case, and we've had the already letter by that stage. So the Secretary of State's stance was known. And Mr. Burns, Miss Malik, the Chief Executive of DRUK, then goes on to point out the impact this will have. First of all, page 59, there was no equality impact assessment. Second bullet point, not referred to in the extensive explanatory notes, the point I've made, so this is the first we've heard about it. And then the point is made, these are the percentages I adverted to earlier, only 16% of disabled people have a degree level qualification compared to 30% of non-disabled people. And the universal credit situation will inevitably make this worse, adds to barriers, bars disabled people from accessing residential college if they're unable to access housing cost support. And that chimes with the point that Mr. Burns amplifies.
Butler,
sorry, Mr. Butler amplifies, which is what this is inevitably going to do is force you to choose a university that's near to your parental home because you won't be able to pay for lodging. And that may greatly narrow the range of courses available to you because of that circumstance. The other thing he says it will do is drive more and more disabled students into part-time education as opposed to full-time education. So there's the gauntlet of the PSED being thrown down as early as July 2017. That should all start alarm bells ringing. The response is at 87. Mr. Hines, the then Minister for Employment, replies saying that second paragraph, a lot of full-time students, including disabled students, are not entitled to universal credit because financial support is available through various loans and grants. And that doesn't address the differential cohorts and their differential treatment. The design of universal credit is different from ESA. The rules are designed to encourage or enable someone in receipt of UC who is disabled to take up further education. That's in other words, don't deter people by taking away their entitlement altogether. And then for disabled student to claim UC, they must be entitled to one of the benefits and have had capabilities worked assessed in one of two ways. And the two ways identified is with work capability assessment and treated as, i.e. Schedule 8, having limited capability for work. That's it. No response to any of the EIA concerns or issues at all. Now, at that point, I think it is helpful to look at what Miss Garrett says in her first witness statement. It's paragraph 32, it's page 121 to 22 of her Why do I say at that point? Well, this response you've just been looking at is dated the 17th of August 2017. Badu has landed 16 days earlier. So it's a response to DR UK, not just with the DR UK complaints on the Secretary of State's desk, but with the advantage of Judge Pointer's decision.
Sorry, you've lost me on the dates. The letter you just showed us of the 17th of August. I thought Badu was September.
That's the first. September is the date of the
First of
refusal,
August.
2016. Yeah. The decision of Judge Pointer is the 1st of August.
It is the 1st of August, right? Sorry,
2017.
Yeah.
The letter in response to DR
No, I've got it now. It's the date of Badu that I got wrong. I thought you told me it was September, but it's August, okay?
Different year.
Yeah. So he's got Badu on the 16th.
My lord, I'm sorry to rise, but that's not right. The
Oh.
hearing was on the 1st of August. If one looks at the date that the reasons and the judgment was sent out, that's at page 138. One sees the date there is the 22nd of September 2007.
Yeah, that's what I was. Yeah.
I'm so sorry.
So they hadn't got it. So it hadn't landed on the desk. Yes. So I was right. Gosh, I was lucky, wasn't it?
I was wrong.
Yeah. Even statistically, I can get it right once. Yes, right.
You were right, but the
Just
point I was
make a
going
note of that. Yes, I was right. Wednesday.
I will write it
23rd.
down, sign it, and deliver it to my Lord's clerk. by no later than 5 o'clock.
Right.
This is why we keep
We're
a
on
watch
page
on all
121 of the supplementary.
Yeah.
Notwithstanding my crass failure to
Notwithstanding,
get
yeah.
to grips with the facts of this case, the point I was making in relation to paragraph 32 at page 121 is nevertheless a good one.
Right. And what was that point? I've forgotten now.
The point was that Badu triggered
Ah, right, yes.
questions for the Secretary of State as to how to proceed. And those are set out at page 121 to 122 in paragraph 32 and 33. My Lord hasn't read it with Badu in mind. Can I ask you to reread it? So the options on the table are clarifying the regulations to make clear on their face the original policy intent, i.e. what eventually happened in 2020. Amending the regulations to allow more disabled students to claim UC, in other words, allowing them to have an assessment, ignoring the fact that they could already have an assessment, but in other words, probably leaving the regulations.
Yeah, but you've got to read this in what she's not in the right universe. It's not clarification and so on, but we know what she's getting at.
Yeah,
the matter of
the
English.
options are...
Spin and jury points don't really help.
I'm not
Yeah.
trying to engage in spin.
Yeah.
Option 1 is to make absolutely plain the operation of a no new claims policy.
Spell out what we really think we thought.
Option 2 is to allow the system we accidentally designed to carry on operating.
Yeah.
Option 3 is to delay the point of entitlement to the point of WCA.
Yeah.
And option 4 is effectively a plague on all the houses.
Nobody gets it.
Get rid of everything. Now, at that juncture, you'd expect that looks a lot like policy formation, with respect. That looks like you're considering policy options. At that juncture, even if you haven't in 2012 begun to think about the equality impacts, you would surely do so at this juncture. But there is no equality impact assessment at this stage. Hasn't been disclosed, so we can infer it doesn't exist and it didn't happen.
Yeah.
Instead, the decision is taken not to amend the regulations. I won't make...
i.e. do nothing.
i.e. do nothing, even though the current situation is said to be unlawful.
And do you have to do, are you exercising your functions for the purposes of 149 if you don't actually do anything and don't exercise any functions? Is not doing something the exercise of function?
What the Minister is doing here is plainly making a policy decision to continue to operate the law as she thought it should be, notwithstanding the fact that the FTT tribunal has said that is not the law and people nevertheless remain entitled. That would trigger a PSED obligation. It would also trigger a wider obligation because one asks the obvious question, how can you do that if you're under a legal duty to assess?
But she thinks, presumably, that a tribunal decision of first instance doesn't bind her, and she presumably thinks that there's other interpretations. But she'll lose every time, though, then, because everybody will take her to the FTT and the decisions will be short. See what I said some moments ago? I meant it.
You really are going to accuse me of jury points now, but the normal response if you don't like a judgment on a point of law, that would be to appeal.
Yeah.
Not to ignore the judgment.
Well, if she doesn't appeal, she'll just lose every time.
Yes.
Yeah.
Yes. And it's that issue that then comes to a head in causa.
It's the ostrich in the sand approach.
Correct. And the causa challenge was conceded, as you know, on the 31st of July 2020. And the statement of reasons, you can see the concession at page 161 and the draft order put up to the court at 167. The agreed statement of reasons, which was required to persuade the court to make the declaration that was made, was at 169. Can I just ask you to look at the first two paragraphs, and it's in particular the second paragraph. The claim challenged the defendant's interpretation of Regulation 14b as expressed through her written policy guidance to decision makers and applied to the claimants. So the policy that had been captured in all those different versions Miss Cadd has exhibited was itself an object of the challenge and was unlawful. Case conceded on the 31st of July. The order was made by Mr. Justice Fordham. You can see that at 173. That was on the 7th of October after the vacation. And we have part of his reasons at 175. And the only point that's relevant is paragraph 2 of the reasons, which again makes the point.
It's not the judge's reasons, it's just that you've got to have reasons, and these are their reasons, aren't they?
Well, they have to be effectively reasons that the court finds acceptable to justify the grant of a declaration. Because of the erga omnes effect of the declaration.
Okay.
So that's then the prompt for the 2020 regulations. We picked through the wording of the old regulations. Now let's go back and look at the new regulations. Authority bundle, tab 7. Page 57. Just to confuse matters, what was 14b now becomes 14(1)b. You've got the same wording up to the words determined. Then what can be determined, LCW or LCWRA under these regulations or the ESA regulations, or that the person is to be treated as such under Schedule 8, or that the person is treated as having a limited capability of work-related business under Regulation 19, etc. None of that's, that last one's not relevant. And then the key rider is, and that determination was made on or before the date of claim for universal credit. So the key point here is not the date you entered education, it's the date of claim. And by the time of your claim, you have to have in your hand a piece of paper saying that the Secretary of State has accepted my LCW. If that's at your before you go to university, great. If it's in your first term of university, great. If it's in the last day that you're at university, great. The trick is to trigger a determination. And of course, reformulated in that way, there is no obligation under the relevant parts to conduct an assessment under the universal credit regulations. And therefore the trick, as explained in the submissions and the evidence, is to find some other means by which you get an LCW determination.
Why is there no duty when you've got a claim still to determine it, even if it's because it's got to be made the determination's got to be made before the date of the claim. Yeah.
That's the trick.
That's the trick.
That's the trick.
So the main route of circumvention, it would be a very unusual case where somebody had a sufficient record of national insurance contributions to be entitled to ESA, but if you were, that would then trigger a WCA. But the more usual thing to do is to apply, knowing that you won't get the benefit, but will be credited with contributions, and that too will trigger a WCA. And that was the route Mr. Keyes eventually took. And that was always known to be a workaround.
Before.
At the time of passage of this regulation, and indeed beforehand, it was known to be a workaround. The Secretary of State in her submissions has pointed out that the Child Poverty Action Group was pointing out in its very helpful guidance the existence of this workaround, even when the no new claims policy was being operated unlawfully.
The ministerial submission, I don't know if you're taking us to that, I thought that did say that. I mean, I thought the ministerial submission actually drew attention to the...
It did. It did, and the importance of that, my lord, is that the minister went into making the regulations
knowing about the workaround.
Eyes wide open.
Yes.
Absolutely. Now, there's a couple of explanatory notes and memorandum I should show you. The first is in Authorities Bundle 9. So it's the regulation that inserted these provisions. The explanatory note simply describes 101 the effect of this change, and it contains the cut and paste rubric. A full impact assessment has not been produced for this instrument as no significant impact on the private, public or voluntary sectors is foreseen. And you have my point that actually the whole reason is predicated on a transference of, if you like, responsibility from the Secretary of State to those very sectors. And then the second thing that I should show you is the explanatory memorandum, which is in the supplementary bundle at tab 6, exhibited to Ms. Garrett's statement.
Okay.
142. That's right, I've got the wrong reference. Completely wrong. Supplementary 6161. Starts at 162. Sorry, Joe, thank you. Let's start with the purpose. Again, it's for the purpose of the Joint Committee on Statutory Instruments. Purpose of the instrument 2.1 is to make it clear that the exception from the requirement, etc., must already have been determined. So it's to implement the no new claims policy. 3.1, these regulations invoke the urgency provisions to the SSAC, which I've shown you in section 173. And it'll also breach the 21-day rule. Why so? Because of the need to ensure continuity of existing policy. Or, putting it slightly more accurately, to put the existing unlawful policy on a lawful footing.
Yeah.
And then 7.1 to 7.3, what is being done and why. This is the pivotal passage, along with the submission to Minister, that shows what the justification was for not consulting. The amendment restores the policy intent, which was arguably not supported under the existing framing of Regulation 14B. It makes clear that the requirement of this regulation, the person must already have been determined to have LCW. The policy enables disabled people already assessed to enter or remain in education and better their prospects. The purpose is not to enable a person to be referred to for a WCA in order to determine whether they have LCW. In addition to a disability benefit, you must you're able to receive financial help from the student support system, including, for instance, DSA or discretionary grants. And then 10, consultation outcome. Given that the amendments restore the original policy intent, no consultation has been undertaken. So that's the reason given to Parliament as to why there has been no consultation. It's because the original intent of the 2013 regulations, the unexpressed intent from 2012, has been restored. Existing guidance will continue to be used. 11. 12.3, no impact on business, charities or voluntary bodies, no impact on the public sector. An impact assessment has not been prepared for this instrument because this change restores the policy intent. So they don't even share with Parliament the equality impact assessment or anything of that kind. That's the explanatory memorandum. Then we have the submission, which is at 142. It's an urgent submission because of the urgency procedure. See that in 2. These regulations follow the procedure for laying urgent regulations and have not yet been before SSAC. And note, a draft letter to SSAC is attached to Annex 5. I'll show you that letter as sent shortly. 6, the Minister is asked to approve the equality analysis at Annex A. And then key information, 10. The amendment restores the policy intent, namely to allow disabled claimants who have already been assessed as having LCW, etc. Policy intent was arguably not supported, etc. We need to make the amendment now with the coming into force date of the 4th of August as a result of pending litigation, where the Department will have to concede. That must only be that there is no lawful defence to the case. that the current policy breaches the UC regulations as currently drafted. The regulations will breach the 21-day rule to ensure continuity. We are not making this explicit in the explanatory memorandum because the conclusion of the litigation remains confidential, which is a bit of a strange justification in circumstances of the Badu case and the wider issues in the litigation, but so be it. If we make the changes under urgency, we can proceed without the normal advanced consultation with SSAC. 13, you can see...
And 12 is important too.
I'm sorry, my lord?
12 is important too. It says what they're going to do.
Yes.
Must already have been determined.
Yes. Then they're saying that no new claims policy was confirmed in advice provided to DR UK in March 2017, the letter I've shown you, the letter with the word already, that's the sum total of it. And then if we skip on to 15, an equality analysis attached as Annex A has been carried out for these regulations. Whilst it's acknowledged some disabled students will not be entitled to UC, this is considered to be justified.
When you look at 14 too, you can't really skip it because 14 is where they recognise that there is the workaround, but they say why it is that they're not going to deal with that. So you've got to look at 14 as well, I think, to be fair.
No, I had meant to draw specific attention to that. I wasn't trying to...
Well, I'm trying to help you, Mr.
No, very helpful. Very helpful, my lord. Very helpful indeed.
The second time I've tried to help you on that point.
No, I'm not looking gift horses in any orifice, mouth or otherwise.
Yeah. But you want 14, I think.
Yes, I do, because it shows that the continued operation of the workaround is deliberate, conscious, and to be kept under continual review. Yeah. It's that passage Mr. Justice Swift alights upon.
Yeah.
And we'll come to it in...
Wait and see.
And then 15, you've got the equality analysis referred to, but let's look at the full detail of that. And then the basic justifications at 16, which is the policy should be limited to the person who's already got the benefit. It's intended as extra support to such a claimant with the intention of giving them better prospects of moving into work. And again, you have my point, subject to your scepticism about my rationality argument, that benefit is just as much a benefit whether or not you've made a claim beforehand or not, because it means that you have a meaningful chance to go to university and won't be deterred by the cost of so doing.
Just so there's no confusion, I'm not expressing a view one way or the other as to whether that's a good idea, a bad idea, a correct or a wrong idea. All I'm saying is, and it's a question, is that what politicians are there for, to make those kinds of choices?
And the answer to that is yes, subject to rationality.
Yes. Just so it's not thought in this court that I'm saying it's not a good idea or I'm saying it's a bad idea.
We can give it all the usual non-fuller resource allocation, multifactorial problems, etc. It's all of those subject to rationality, and it's a high bar. So then look at the annexes. You can see they include the equality analysis and the Annex F draft letters at the SSAC. And then the equality analysis starts at 148. All of 148 on the introduction up to a brief outline of the policy is just background as to the PSED. You've got the language, the penultimate paragraph, the department is also taken into account, etc. That's to head off the Lord Justice Elias concern from bracking. It's now become boilerplate that you say you've taken all these things into account. And then brief outline of policy. The no new claims policy is thereby described, culminating at the end, the UC regulations are being amended to support the policy intent, namely to make clear that a disabled student with a qualifying benefit must already have been determined to have LCW to benefit from this provision. And then we get to the equality analysis, the evidence and analysis, and it consists of the passage at 149 under the bold heading, through to the heading protected characteristic, and then no analysis in relation to age because it has no bearing on the policy. That's wrong, as we've explained. And then there's a further paragraph in relation to disability. That is the sum total of the equality impact analysis. The passage at 149 to 150 above the heading protected characteristic is an analysis at the very, very highest level of generality as to the legal effect of the rule. It is not any kind of analysis as to the factual impact of the rule or as to the context in which the rule is going to take effect. It simply explains how the policy is going to work and therefore why a cohort of disabled students is going to be disadvantaged thereby. Now, identifying the differential impact of that kind is only the beginning of the analysis. You then have to look at the factual consequences. When one comes to look under the heading of disability, this is as close as one gets to the kind of evidence with which Lord Justice McComb was clearly centrally preoccupied in the case of Bracking. And there is woefully little here. There's no granular analysis of any kind at all. There's no attempt to identify how many new claimants there are that would be disadvantaged, how many have in fact been refused, how many claims might have been suppressed.
Sorry, how many disadvantaged, how many claims refused?
So we know people have claimed and been refused. We don't know how many of them there are. We know some people have claimed and managed to get through, and they've been sent the policy telling them not to do that. That's paragraph 30 of Ms. Garrett's witness statement.
So we don't know we know identification of how many disabled students there are, how many claims have been refused, yes.
How many claims have been admitted notwithstanding the policy, how many claims have appealed, and we also don't have any analysis of how many people are in the existing claimant cohort. In other words, how many people have benefited from the rule that if you've got your benefits, you don't lose them. None of that. Nor is there any analysis of the financial delta, to use that terrible financial term.
And can I just check how many have benefited and will not lose? Just elaborate. Those who've already got through the network by one way or another, nobody's suggesting that anyone who's already got it will have it taken away, is there?
No. But we don't know how many workaround cases there are, and we don't know how many cases where the determination has happened, notwithstanding the unlawful policy.
Yeah, because if you're not taking it away from anybody, then do you really need to spell out the fact that there are 10 or 20 or 40 or 200 who will not in fact be affected because we're not doing something?
Well, that's material, because how many people fall into the workaround is obviously material to the impact, effect and necessity for the exception.
We're at cross purposes. I know what you're saying. You don't know what I'm saying, but I don't think it matters. Yeah.
I do try to listen very carefully.
Don't worry about it.
No analysis of the financial impact, you were saying?
No analysis of financial impact. So those figures that I've shown you that were given to the SSAC, none of that is apparent here. So the Minister isn't told what this is going to mean is that the students are going to be disadvantaged to the tune of 4,500 to 5,500.
All he'll know is that they're not going to get UC, universal credit.
Correct.
Yep.
And that number is relevant because that's, if you like, the shortfall that has to be addressed by means of alternative provision that can address the subsistence needs of the beneficiary. Not the types of needs met by DSA, but the daily living needs that income support, universal credit is meant to meet.
Out of the long list of things you've said, the key points really aren't there how many disabled students this affect and how much they're going to lose, because that's what you really need to know.
How can you do an impact assessment without those figures? It's meaningless.
No, I know. Don't go off another flourish. You've given us a list of 20 million things, but the key things is how many students and how much are they losing, isn't it?
I agree that is absolutely top of the pile.
Yeah.
And then can I ask you to note the section headed Monitoring and Evaluation?
Yep.
The DWP is committed to monitoring the impact of its policies, and we will use evidence from a number of sources. Whilst we do not propose to undertake a formal evaluation of these changes, we will, however, monitor the impact through our regular liaison with local authority associations. Well, that begs the obvious question. Why haven't you been doing that for the last 5 years? And use feedback from them and other stakeholder groups to assess whether there are unintended consequences for the protected groups and whether the policies themselves result in adverse consequences for the affected groups. The most obvious adverse effect is that, contrary to the Secretary of State's predictions, that shortfall for some or all students won't be made up by hardship bursaries or other discretionary or charitable donations, and that students will be deterred from going to university, or through straitened financial circumstances will give up their studies halfway through because they can't make the numbers add up. Now again, there's 4 years of data. None of that's been investigated. We're also considering whether it's appropriate to consider this issue in the context of a wider policy in the anticipated Green Paper on Health and Disabilities. The UC is required to gather and report equality information relating to the 9 areas described above. From the 6th of January 2016, information regarding age, gender, disability, etc. was requested from claimants after they completed the declaration. It's optional, with the information gathered being totally confidential and never impacting on a claimant's ability to claim UC. The use of this data is yet to be evaluated, as is the need for consideration as to its robustness.
So it's looking at intersectional impacts.
Yeah, at least they haven't even started that exercise, despite gathering the data from the 6th of January 2016, in circumstances where whether or not disability questionnaires have been, or equality questionnaires have been completed, they would have within their system surely information about adjustments made to UC for people who enter tertiary education after receiving universal credit, the recalculation required for taking into account of the maintenance income. Then when will the impacts, potential impacts, be reviewed? They're committed to monitoring the impacts, etc. So far as we're aware, but may not be strictly germane, there has been no such review. So that's the impact assessment. And can I ask you to note in particular the last sentence of the section headed disability, where they say the application of this policy is limited to a disabled person who has already been determined to have LCW. Well, that's strictly speaking not
Sorry,
right.
I don't see
Last
that.
section of where?
Page 150, the
Last sentence.
last 2 sentences.
Oh, right.
The application of this policy is limited to a disabled person with etc. who's already been determined. Well, that's not true. The application of the policy, it benefits them and disadvantages others.
Hang on, those is limited to.
It restates the purpose is in order to give them better prospects of moving into work, given that they're already in the benefit system. And then there's this. Others, i.e. new claimants, are able to make decisions about becoming a student in the light of the student funding available to them, or will continue to be a student on the basis of student funding that they've already secured. Now, this is very odd, because it seems to be saying you'll be put off if you lose benefits. Why will you be put off if you lose benefits? Well, because the prospect of the shortfall, the 4,500 or 5,500, being made good by bursaries, isn't concrete enough for you to want to enter into education.
Well, I thought they were saying if you've already got it and you're losing it,
yes,
it's a different thing from you set out and you
Correct.
know what you've got to start with.
Correct. But what's the disadvantage? What's going to put people off going into university education in those circumstances? It's that you lose £4,500 or £5,500 of guaranteed benefit receipt, and you have the uncertain prospect of replacing it with all the discretionary things that are said to be available. That is a deterrent to entering the system, and because it's a deterrent, it must be removed. But why is it not a similar deterrent to enter the system to say, I need to find this extra £4,500 or £5,500 I need to live, particularly if I want to live in halls at the course in York that I want to go to and I live in London. And because I can't find the money, I'm not going to go to university. That point, which is surely the central point in the differential treatment, is simply not addressed in any way in the impact assessment. So, the last bit of the chronological review is the engagement with the SSAC following the regulations. We can pick this up with the letter at page 165, which I believe is the same or similar to the draft provided to the Minister. Supplementary Bundle 165, letter of the 4th of August.
Did you say 105?
165.
165, I'm sorry. Yeah.
Why is all this urgent? Why have we cut you out and acted without consulting you? It's the same justification. The DWT needs to ensure continuity of the existing policy so as to maintain the effective administration of UC. In other words, they don't want to be changing their systems.
So they did nothing for 3 years and then they said it was all such a rush because of the litigation in the High Court.
Yeah. Private lawyer might call that self-induced frustration, but...
You might call it bad government. Question is it unlawful?
It is if it unjustifiably impacts on the quality of the public sector equality duty analysis.
That's the question. You
can't put it out of your power to do matters properly by doing everything at the last minute in a rush because you've operated consciously an unlawful policy for 2.5 years. Following that letter, there was a meeting attended by Miss Garrett on behalf of the Secretary of State with the SSAC. You have the minutes for that at page 176 of this same bundle. You can see the members attending are set out, and the DWP attendees are set out at the end of the minute at page 184 and include Miss Garrett. And in this meeting, a series of questions were asked about all of this. So the broad background first of all, question A, page 177. Why is this an urgency case? It's not obvious to us why it was an urgency case. And the answer is given that the urgency is driven by the JR. No mention, I should point out, of the Badu litigation at all.
The Badu litigation didn't drive the urgency. Perhaps it should have, but it didn't. So the factual answer is right. We've been found out, if you want to put it pejoratively.
Yes, I think a full answer might have entailed this had already been identified by an experienced judge in the tribunal system 2.5 years earlier.
We could have avoided the urgency if we'd seen the writing on the wall, but we didn't look at the wall.
I think I'm not putting the point any point higher than this. If you were,
we've got the point. We've got the point.
Then D, what would change? What would the claims? How would the claims process work, etc. They say from a policy perspective, the original regulations were confusing. Well, that may be true, but they were never articulated, those policy concerns. From a legal perspective, it was abundantly plain. And then G, the policy intent was not clear. For example, what about students who've just had student finance? Student finance was not all given as a grant, etc., etc. The answer to that is the DWT was trying to keep the customer journey straightforward, and financial consideration was taken into account. So fourth, H. This is a hard question. What discussion had taken place with Bayes about the different groups for different situations? How much is known about the degree to which this policy enables disabled people to better their prospects of work? And that's dead batted. Bayes and DHSC would be better placed to answer that question. Then there's a question about numbers. What are the numbers of people trying to claim UC before the new legislation clarified the position? So it's about people trying to claim, not about the people eligible for claim who were deterred. That's said to be not a huge number. Even if there was a small number, we needed to make the legislation clearer. The number of disabled students attempting to claim up to the point the new regulations came into force was low. Disability Rights UK and CPAG guidance made clear that students needed to have LCW and had advised that disabled students had no entitlement if they'd already not already been determined to have LCW. No, that's with respect not fair. They'd advised that that was the stance of the department, and they'd also advised on the existence of the workaround. So insofar as they're trying to pin it on those institutions, that's perhaps a little unfortunate. But the department was concerned about avoiding any gap. Why? Because they were concerned there'd be an influx of claims if there were a gap between the coming into force date of the regulations. The number of people claiming under the old regulations was limited. In other words, the problem wasn't the claims that had been made, but the suppressed claims. The financial difference was not considerable and was not an issue, but what financial support would you get on UC? And you get an answer in relation to that about the basic maintenance loan. And then I think we can skip on to I. To understand this better, could we have a few scenarios on the financial situation? That's where that document I showed you earlier came from. For example, over 25, have children disabled in education, could you provide some numbers? And the answer provided here is then expanded, as I'll show you, in the form of those scenarios. And then M is of interest. Student loans would have to be paid back. Would you know what's available nationally rather than locally? A flowchart would be good if one could be provided. We have previously mentioned that the quality of the equality analysis needed to improve. There needed to be improved quality of data, and the data on the characteristics was sparse. Do you have any data? And the answer is the department did not hold that data and was not sure what steps were being taken to support the characteristic. There was a limitation on what data was held, and the best assessment had to be made on the data available. And again, that doesn't mention the fact that the policy's been operated for 4 years and no data started collecting data. That feeds into N.
So what would this paragraph about actually then? What data are they saying they don't have?
Data to support the and improve the quality of the equality analysis.
No, I know, but in what respect? Because it looks from the last sentence of M as if it's the age point, because that seems to be the only bit in the equal impact assessment that says they don't envisage any adverse effects on the impacts of the policy, and the answer seems to be picking up on age as well. It's just limited to that issue, isn't it? Or have I misread it?
I don't think so, but I'm very nervous given my Lord's strike rate so far. I'm disagreeing with you.
Lucky guess. I mean,
I don't think it is.
Just the last sentence and then the other bits of the answer.
What, the data limitations cause frustration?
You know, does the department have any data to support your statement that you are not envisaging adverse impacts of the policy? That's the question. And I thought the only bit in the equality impact assessment, without going back to it again, was under the heading age. That's the only bit at which it said, I think, we do not envisage any adverse impact. And then bits of this talk about being young, a state some of us can vaguely remember, and it makes me think this is all about that bit in the equal impact assessment talking about age. Could be another lucky guess, Mr. de la Mayor.
Once again hit, my lord.
Yes, I know.
Probably right. N. Would DWP start collecting data? On the policy side, DWP was very keen to obtain data. On the operational side, the DWP needs to focus its resources on making sure the service runs well and that payments are made. I think that's Sir Humphrey for no.
The only thing that bothers me is, sorry, going back to M, because one of the criticisms that made is the section on age, not about the disabilities, but they say the department did not hold that data, they talk about specific data, and I'm just speculating in my own mind. If they don't have the data about age, I know, and I've written down a number of times now all the bits about the massive amounts of data they haven't got, but looking at age alone, which is part of your claim, if they didn't hold the data about age and they wanted to do it urgently, is that lawful or unlawful, or?
Well, it's unlawful because it suggests that you're not in a position to address one of the key considerations under the public sector equality duty, notwithstanding the fact that you've been implementing the policy.
So if you haven't got data on something, you just can't do it. You've got to wait until you get the data. You can never do an urgent policy or if you haven't got the data. I mean, whether or not you should have got it, you haven't got it.
Well, I think that comes down to the quality of the justification for not having the data, doesn't it? If there's suddenly, let's say, a COVID scenario where you absolutely have to act urgently in response, and one of the measures you're taking pulls you into terrain where you don't have the data, that may be a justification for not having the data. But where you've been operating the policy for 4 years...
Yeah, that's a different point. I'm not into that, as I did just say. Yes. I'm really looking, if this is just about the mature students going in and they haven't got that, I'm just wondering in my own mind, I'm trying to explore if that is what this is about. If they haven't got it, what then is the legal consequence of them not having got the data about the proportion of mature students that have benefited, if you like, rather than the number of straight university students who are disbenefited.
If there's no good reason for not having got the data by the time of the assessment, then that will impugn the discharge of the assessment.
Right. So it can still be relevant. Okay. Right. Yeah, sorry, yes, I was obsessed with M. You'd moved on in the meantime to say something with Sir Humphrey. That was N, was it?
That's N.
Yeah.
We'd like to have it, but resources, policy would like to have it, but operational side have got better things to be getting on with, is really the gist of it. So what then happened is immediately after this meeting, in furtherance of the request for scenarios in one of the earlier questions, the SSAC followed up with questions. You see that at page 202. You go to the originating email in the chain. It starts at 201. In this new form, we're not even allowed to know the names of the people sending the request. They've all been rejected. It's someone from the SSAC sends a question, and they set out their ask in 1, 2, and 3. That's where the request for the scenarios comes. 2 is the department has identified there'll be a small set of group of people sick will be affected by this change, and the committee would like to receive further information on these, please. And then 3, the committee is keen to understand what engagement there has been with BAYS and DHC to look at the different group scenarios, etc. And it's that answer that then generates the response that starts at 200 in general terms and prompts the provision of the materials that are at 204 and following. The 204 lists all of the structured discretionary support, and then 206 onwards are the various scenarios that I showed you earlier, and we don't need to go back to. That obviously prompts the relevant question, why wasn't that done for the minister, who had to take the decision personally? Why wasn't that information supplied in the EIA? Which it wasn't. Last section, and I think I can rattle through this in the 5 minutes remaining before me, which means I've made very good progress with my note. I just have the grounds to get through tomorrow, which will be speedy given the ground we've covered. The facts of my client's case. And we can take these very quickly, not least since the material facts are largely set out in Mr. Justice Swift's judgment. Paragraphs 1 to 4. That's 4, tab 12, page 93.
Yep.
The nub of it is that he suffers from a number of serious conditions. There's no need to go into the detail of them.
No, we've got them in writing.
The key factor is that he's had awarded to him not just both components of the PIP, that is, the components to address mobility enhancement. So he has a very serious impact upon him of his conditions.
Yes.
And I know that the court will have read very carefully the evidence prepared by him with the assistance of his mother to describe the effect it's had on him and the difficulties that he's encountered. What the judgment doesn't record, but it's common ground, is that eventually he has benefited from the workaround.
Yeah.
Before it too was peremptorily closed in the back end of, I think it's November 2021.
Yeah.
And you can see the dates in Authority Bundle 10. Again, that was done without an impact assessment.
But that hasn't affected him. He gets it because he got in before.
He continues to get it now, and
Yes.
you're not challenging the closure.
Yeah.
You really must go back to your claim form. I'm sure you read section 3.
I know. With respect, I know.
You're just telling
I'm just
us.
telling you.
Telling us,
I was about to say that's a debate for someone else on another day because it's not the target of this litigation.
Unfortunately, for your client, he does have it eventually, albeit that his mother explains, well, he explains with the chart about the number of times she was on the phone for 60 minutes, 40 minutes, and she too has to run her life, and we've seen it.
I'm glad you said that Because when we get to the thicket arguments, it won't be the last time I mention my client's mother, because it's substantially due to her persistence.
Yes.
We're here, and he receives the benefit he has, and without someone like that supporting you and accessing the specialist advice from CPAG or DR UK.
And she has her own issues too to deal with. She can't spend every day 45 minutes, an hour on the phone to somebody who doesn't really answer it. We've got no illusions about that. They had a runaround beyond what anyone should get, and particularly given the things they had to deal with in their own individual lives.
Well, I'm not going to labour that point any further. My lord's read the evidence and it tells a compelling story. Is that a convenient moment then to break off today?
I was going to ask you how far you'd progressed in your note, but you've already told us that we're making good progress. No, I wasn't asking for a page number.
Yeah, we need to know the...
Mr. Dillerman, you're going to finish comfortably before 12 o'clock if we start at 10:30. There's no need to start early tomorrow. That's really all I need to know. Thank you very much. 10:30 as usual tomorrow then.
All rise.
Wait until he'll be the same as me tomorrow.